The Federal Trade Commission, or FTC, recently filed a lawsuit to stop Microsoft's $69 billion acquisition of video game developer Activision-Blizzard. As we discussed in my last video on this topic, the FTC claims that the deal violates federal antitrust law. Specifically, the FTC alleges that the deal would violate Section 7 of the Clayton Act and Section 5 of the Federal Trade Commission Act, the FTC Act. So in this video, we're going to look at Section 7 of the Clayton Act and the specific legal elements that the FTC must prove against Microsoft to win the lawsuit and block the Activision-Blizzard acquisition. Now, quick disclaimer, this is not legal advice. If you have legal questions about a specific situation, talk to a lawyer in your state. In its complaint against Microsoft, the FTC alleges that Microsoft's deal to acquire Activision-Blizzard violates Section 7 of the Clayton Act. Now, a little bit of background about the Clayton Act. Congress passed it in 1914 and then made major changes to it in 1950. It's a civil statute, so there are no criminal penalties for violating it. It prohibits mergers and acquisitions that are likely to lessen competition between companies in a given market or industry. The Clayton Act allows the government, through the FTC and the Department of Justice, to challenge mergers and acquisitions that are likely to increase the price of goods for the end consumer. Now, Section 7 of the Clayton Act is found in Title 15, United States Code, Section 18. The portion of this statute that is relevant to the FTC's lawsuit against Microsoft states that no person shall acquire directly or indirectly the stock of another person engaged in commerce where that acquisition may be substantially to lessen competition or to tend to create a monopoly. Now, you might be wondering, why does this statute say a person, no person engaged in commerce and not a company? Because obviously Microsoft is not a actual real human person, but not so fast. This is the United States where corporations are in fact people. And in fact, under Title 15, United States Code Section 12, Congress has actually defined persons to include corporations in the U.S., including Microsoft and Activision-Blizzard. So Microsoft falls within the definition of person for purposes of this statute. Now let's take a look at the most important portion of this statute, the part that says that the FTC must show that the effect of the acquisition may be substantially to lessen competition or tend to create a monopoly. Now, courts have noted the fact that the statute's reference to the word may lessen competition rather than will lessen competition means that the FTC doesn't have to prove beyond a shadow of a doubt that the merger or the acquisition will actually in fact lessen competition or create a monopoly. Instead, the FTC just has to show that it is probable or more likely than not that Microsoft's acquisition of Activision-Blizzard will in fact lessen competition or monopoly in the relevant market. So now that we've defined the key terms in Section 7 of the Clayton Act, let's look at the framework that the administrative law judge who will decide this case will most likely apply to determine whether to block this deal or not. The courts, which the administrative law judge will likely follow, have applied a burden-shifting framework to Section 7 violations of the Clayton Act. So what is this framework that the administrative law judge, the ALJ, is going to apply in this case to decide whether to block the acquisition deal that Microsoft has made with Activision-Blizzard? Well, the framework is fairly simple. It's called a burden-shifting framework, and this is how it works. First, the FTC must define the relevant market that it is wanting to block an acquisition in, that it believes there will be less competition in. Once the FTC has defined the relevant market for purposes of its claim, it must then present evidence showing that Microsoft's acquisition of Activision-Blizzard is likely to lessen competition in that specific relevant market. If the FTC is able to carry its initial burden, then that burden will shift to Microsoft to offer evidence that casts doubt on the accuracy of the FTC's evidence predicting future anti-competitive effects if the acquisition is allowed to go through. In other words, Microsoft will then have the burden to poke holes in the evidence that the FTC brings forward to show that This acquisition is bad for competition, it's bad for the consumer, it's going to increase prices for the end user, the video gamers who are playing these games, and it's going to decrease the quality of games. Microsoft has to basically come forward with evidence showing that that is not in fact going to be the case, that is not likely to be the case. The FTC bears the ultimate burden, however, of persuading the ALJ with evidence, that's the judge, by the way, with evidence that the acquisition will likely lessen competition in the relevant market. So you might be wondering, okay, so the first step is that the FTC must define the relevant market. How has the FTC defined the relevant market in this case? Well, the relevant market consists in all cases of two components. First, the product market, and second, the geographic market. In its complaint filed on December 8th against Microsoft, the FTC identifies three different relevant markets. On pages 11 and 12, the FTC talks about the first relevant market being the market for high-performance gaming consoles. In paragraph 64, it claims that the Xbox and Sony consoles are the only products for sale in this particular relevant market, in the high-performance console market. In paragraph 65, it kind of takes a shot at Nintendo by saying that Nintendo Switch, it is not included in this high-performance console market because it is, quote, highly differentiated from Xbox and PlayStation consoles in significant ways. And then in paragraph 66, it goes on to say that Microsoft and Sony consoles are high-end, but the Switch, made by Nintendo, is not because the Microsoft and Sony, the Xbox and PlayStation have, quote, greater computational power, different content portfolios, different form factors and technical specs, higher prices, and different release cadences. Then moving on to page 13, the FTC complaint identifies a second relevant market, and that is the multi-game content library subscription services online. Then on page 15, the FTC's complaint identifies a third relevant product market. The FTC says that cloud gaming subscription services are one of the relevant markets that this acquisition will make less competitive if it's allowed to go through. And then finally, if you turn to page 16 of the FTC's complaint, it states that the relevant geographic market is the entire United States, and that makes sense because you can purchase video games online or in stores across the US. Next, let's look at the factual allegations that the FTC will try to prove to show that Microsoft's acquisition of Activision-Blizzard may lessen competition in the relevant markets. Now, the FTC's complaint, I must give it credit, lays out a very simple formula for alleging this violation of the Clayton Act. That formula is means plus motive equals harm to competitors, namely Sony, and consumers with less competition. Now, let's first take a look at the means. The FTC alleges that Microsoft has the means to unfairly disadvantage Sony if this acquisition is allowed to go through. So the FTC argues that the acquisition would give Microsoft the means, or as it refers to it as, the ability to unfairly disadvantage Sony's business in the console wars. On page 18 of the FTC's complaint, the FTC alleges that, quote, Microsoft would have the ability to disadvantage rivals by withholding or degrading Activision content in the relevant markets. On page 18, the FTC repeatedly focuses on how the deal would give Microsoft the ability or means to gain an unfair advantage over Sony in the relevant markets. So we've already talked about the means by which Microsoft would unfairly compete against Sony through this acquisition. Now let's talk about why Microsoft, or why the FTC believes Microsoft has a motive, and what is that motive to use this leverage that it gains by acquiring Activision-Blizzard to unfairly disadvantage Sony in the console wars. The FTC's complaint argues that the acquisition would give Microsoft the motive or incentive, as the FTC actually refers to it, but it means the same thing. It would give Microsoft the incentive to disadvantage its rival, Sony. What's the motive? Money is the motive, of course. That should come as no surprise to you. As a for-profit business, Microsoft's core objective is to maximize profits for its shareholders. On page 19, the FTC points out that Microsoft would have the incentive or motive to remove Activision games from the PlayStation and make them Xbox exclusive titles to steal customers from PlayStation. On page 20, the FTC points out that Microsoft has told the European Union regulators that it would not make ZeniMax content exclusive upon closing its acquisition of the company, only to then turn around and announce that it's pulling certain ZeniMax games from PlayStation and making them exclusive to the Xbox. The FTC is implying that because Microsoft pulled the rug out from underneath the EU regulators, told them one thing and then did another, it's probably more likely than not going to do the same thing if the acquisition of Activision-Blizzard, if that's allowed to go through. Then moving on to paragraph 114 and 115, the FTC warns that Microsoft will do the same thing with the Call of Duty games. That being said, Microsoft has publicly said that it is committed to keeping the Call of Duty games available on the PlayStation consoles through the end of Activision's existing contract with Sony, but the expiration date of that contract is redacted in the public version of the FTC's complaint. Now let's look at how the FTC claims this acquisition will, quote, harm competition and consumers in the relevant markets. On page 20, paragraphs 118 and 119, we see the FTC's complaint contains allegations that track the language that we saw in Section 7 of the Clayton Act that we just looked at. That's 15 USC Section 18 that we had talked about earlier in this video. That being said, these paragraphs don't really do a good job, in my opinion, explaining why allowing Microsoft to pull Call of Duty and other Activision games off of the PlayStation and then make them exclusive to the Xbox would actually unfairly disadvantage Sony's PlayStation. The key here being unfairly disadvantaged, because in general, acquiring a upstream supplier, a producer of video games, is a fair competitive advantage that a company should be able to pursue, all other things being equal and competitive. So here are a few arguments that Microsoft may make to show that there will be plenty of healthy competition in the video game console market, even if Microsoft does go ahead and acquire Activision-Blizzard and that deal is not blocked by the FTC. First, Microsoft may say that it has no plans to raise prices on Activision-Blizzard games. Microsoft may even agree to not raise prices for a period of time after the acquisition, which the FTC might actually accept and withdraw its complaint if a deal like that was struck with the FTC regulators. Microsoft may also argue that Sony's PlayStation has a stronger library, or an at least equally strong library, of exclusive games as the Xbox, and therefore Microsoft needs Activision's games, their exclusive titles, just to stay competitive with Sony. Microsoft may point out that there are still plenty of first and third-party shooter games that would still be available on the PlayStation. This includes EA's Battlefield franchise, which I actually like better than the Call of Duty series, Fortnite, Destiny, Ubisoft's Rainbow Six franchise, and many others. Microsoft may also argue that the FTC has too narrowly defined relevant market in which the Xbox competes. The FTC has defined the relevant market as high-end gaming consoles, which only includes Microsoft's latest game console and the PlayStation 5. Microsoft may argue that it competes against all gaming devices, including Nintendo Switch, mobile devices, PCs, and even virtual reality devices, such as the Meta Quest and the Sony VR. When defined this way, the relevant product market for video games seems far more competitive. So that's all I've got in this video. If you liked it, let me know by giving it a like. Make sure to hit the subscribe button and turn the bell notification icon on so that you don't miss any more videos in my series on the FTC's lawsuit to block the Microsoft Activision Blizzard deal from happening. And of course, as always, thank you for watching.